अच्छा, एक छोटा सा सवाल, इन सब के नाम, इन सब चोरों के नाम मोदी 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 कैसे हैं? नीरव मोदी, ललित मोदी, नरेंद्र मोदी, और अभी थोड़ा ढूंढेंगे तो और बहुत सारे मोदी निकलेंगे.
These 15 seconds of what was a 30-minute odd speech made in Kolar 4 years ago has cost Rahul Gandhi his Lok Sabha seat. He was disqualified as Member of Parliament after he was convicted in a criminal defamation case and sentenced to 2 years in prison. His disqualification has reignited the debate on whether defamation should be a criminal offence. From BJP and AIDMK to corporates like Adani and MeToo accused like MJ Akbar, criminal defamation has been used as a tool to harass and to suppress free speech. I believe criminal defamation should be abolished. Why? Let me explain. India has two types of defamation, criminal and civil. Civil defamation allows a person whose reputation has been damaged to receive monetary compensation. Criminal defamation means that a person who is convicted faces 2 years in jail or a fine or both. Sections 499 and 500 of the Indian Penal Code deal with criminal defamation. Defamation has been decriminalized in many countries including the US, UK, Australia and New Zealand. In India, the Supreme Court had in 2016 upheld the constitutionality of the criminal defamation law. It said two important things. One, that the protection of reputation is a fundamental right, and that the right to free speech does not mean that a person can defame another. Second, the court pointed out that the legislature, in its wisdom, had not thought it appropriate to abolish the criminality of defamation. The Supreme Court ruling had come on a batch of petitions filed by many, including BJP's Subramanian Swamy, Congress's Rahul Gandhi, AAP's Arvind Kejriwal, among others. They challenged the constitutionality of the criminal defamation law. Many have criticized the 2016 judgment and have said that the matter should be taken up by a larger bench. So why should criminal defamation be abolished? I give you 6 reasons. 1. Criminal defamation has been used as a tool to stifle free speech and suppress criticism. Those routinely targeted are journalists, activists and politicians. Former Tamil Nadu Chief Minister J. Lalita had filed over 200 criminal defamation cases between 2011 and 2016. 55 of these were against the media. A majority of the cases were filed against the opposition. Arch rival the DMK had 85 cases, DMDK's Vijaykanth had 28 cases against him, and BJP's Subramanian Swamy had 8 cases for tweets against J. Lalita. But it's not just politicians who are using the law. One of India's leading corporate houses, Adani, had filed a criminal defamation suit against journalist Paranjoy Thakurta, who had authored 2 articles alleging that the Modi government had unduly favored the Adani group, helping it expand and evade taxes. The law has also been used to try and silence voices from the MeToo movement. Journalist Priya Ramani was slapped with a criminal defamation suit after she accused editor-turned-minister in the Modi government MJ Akbar of sexual harassment. 2. It is an anachronistic law. Defamation is a colonial-era law that was included in the Indian Penal Code by Lord Thomas Macaulay in 1860. Defamation was made a criminal offence primarily to protect the interests of the British Raj, to protect the rights of the aristocracy, and to ensure the security of the state and public order. This is why many argue that it is anachronistic. It is a relic of our colonial past and one that has no place in a modern democracy, which prides itself in the right to free speech. And for the record, the United Kingdom did remove criminal defamation from its statute books in 2009. 3. Defamation is so broadly defined under the IPC that it makes it easy for just about anyone to file a criminal complaint. The law also enables people to file cases from anywhere. And not just that, there is no limit on the number of cases that can be filed, making the law a tool for harassment. In Rahul Gandhi's case, the complaint was filed by BJP MLA Purnesh Modi in Surat, although the speech was made in Kolar and the Congress leader is based in New Delhi. Purnesh Modi filed the complaint despite not being specifically named by Rahul Gandhi. Those critical of the conviction order say that those with the surname Modi are not an identifiable group, community or caste, and the complaint should not have been entertained as none of the targets of Rahul Gandhi's speech, that is Nirav, Lalit or Narendra Modi, were not the complainants in this case. While the Supreme Court has directed trial court judges to closely examine criminal defamation complaints before going ahead with proceedings, this is rarely done. Complaints are hardly ever scrutinized and are most often taken at face value. The consequences of this is that the accused has to make regular court appearances, has to file bail pleas, and has to bear the cost of a legal defense. The process then becomes the punishment. 4. India's criminal defamation laws have been framed in such a way that even the truth will not set you free. Under Section 499 of the IPC, the accused will not only have to prove that their statement was true, but was also made for public good. What is public good will be assessed by the court. This places the entire burden of proof on the accused rather than the prosecution. What's more, the defense of the accused can only be made during the trial and not at the pre-trial stage. 5. The law is arbitrary. Under the IPC, a person can be booked for defaming someone who is dead. Lawyer Aparna Vishwanathan pointed out in this article for The Wire that the whole idea of defamation laws is to protect a person's reputation so that they may be able to earn a livelihood and live with respect in society, which is why being prosecuted for defaming a dead person is arbitrary, because there can be no damage to their ability to earn a livelihood or live with respect in society. 6. If protecting reputation is the purpose behind defamation laws, then why do we need a criminal defamation law when there's a civil remedy available? Many are also asking why civil defamation isn't enough of a legal deterrent. Why must the state have an interest in protecting the reputation of one individual against another? Criminalizing defamation serves no public interest. What many experts recommend is that while India must abolish its criminal defamation laws, it must also strengthen its civil defamation laws to protect the right to reputation. Until then, this colonial era law will continue to be misused, especially by the rich and powerful. That's all from me for this week. But before I go, a quick reminder that if you value the journalism that we've been doing here at the News Minute, do become a member. Also subscribe to our YouTube channels. And as always, if you like this video, hit the like button and share this video with your friends.